So they themselves said these revenue proposals must effectively suspend the proposed increases. So that too was deceptive because it lied to the public by creating the impression that this VAT rate increase is subject to change. Now we have a speaker who says that it is never subject to change. We had a minister who said it was never subject to change. And they simply cannot answer the problem. So both the minister and Parliament have in fact misled the public. Then there is the problem. I know Madam Justice presiding, you debated with me whether this is deception or shows confusion. And I suggested to your leadership, if it's not deceptive, it shows confusion. Either way, I come home because it's fundamentally irrational. Then the third point is around substantive equality. I actually agree with Ms. Elaine that it would not be possible for the court in these proceedings to do the equality balancing exercise that I am arguing. But the point is not that you should do the exercise yourselves. The point is that it is common cause that Parliament did not engage with the substantive equality problems that its own report identified. And it did not identify it in one paragraph, it identified it in 6 paragraphs. So she's wrong there in saying it was 1 paragraph, it's 6 paragraphs. And they never responded to any of them. There was one response which was 0 rating, but they themselves explained why 0 rating was not possible. So what you can say, which is not complex, which is not novel, is that where Parliament is faced with a substantive constitutional problem, it has a duty of engaging with it at the very least to avoid substantive irrationality. Then the last point is remedy. The only thing I want to suggest insofar as remedy is concerned, firstly, I don't have the problem of not challenging Parliament's decision. I've challenged both of them. I would like both of them to be suspended. But if the interdict that I said in paragraph 5 is to be considered, it has to be clear that it includes the VAT rate increase. The last thing we want is for the public not to know what the consequences of a judgment by this court are. Thank you.
What should the argument, Mr. Ngcukaitobi, that the committee decision had no legal effect?
Well, I don't think it is a correct argument because Section 8 creates the committee as a separate body that makes its own decision that have legal effect, independently of the parliamentary process. And it gives it unique powers. It's not a subcommittee of Parliament, it's a statutorily formulated body.
What is the legal effect?
Well, the legal effect is that when it goes to Parliament with its report, and the report is unlawful, and Parliament acts on the basis of an unlawful report, if it influences Parliament to act, then you could set aside the decision of Parliament on the basis that the basis on which they acted was an illegally adopted a subcommittee report. But does it have legal effect to the public as a whole? I would submit it does, because those committees, what they do, this is the engine of the budgeting process, because this is where they evaluate the submissions we make. They recorded 48 of the submissions, and they evaluated each and every one of them. They are the ones who told us that out of that 48, only 2 supported the VAT increase. It was PwC and PEP. Everyone else objected to the VAT increase. They also have the power, by the way, over the minister. And that's absolutely important, because if you look at Section 8.6, it explains when the report has been amended, what happens. When the report has been amended, it comes back, because the minister is given 2 days to make amendments and then come back to Parliament. So they have power even over the minister when they have made an amendment. And that actually becomes crucial, justices, because if the effect of what Action SA did was an amendment, then it was wrong for it to serve in Parliament, because it should have gone back to the committee for recalibration and redeliberation. But the reason it went through is because they actually never had any genuine intention of engaging with this. Thank you.
So you're saying because of the effective amendment, it should have gone to the minister first.
Yes.
And the minister responds, and then that response is debated and discussed, and then it goes back to the committee before it goes to...
That's the 2-day response.
That's the 2-day response. But the reason it didn't go is what Justice Savage was saying, which is this was a scheme. They never really had any intention of debating any of the schemes. What they did, they got Action SA naively to go with them. And once they procured that vote, then they decided, let's ram this thing through. Now, there is a fundamental problem with this. Public power should not be procured by deceptive means. If a parliamentarian had been bribed in order to secure their vote, that invalidates the vote. That applies equally to a vote that's procured through deception. So the section says 8.6. If the report includes amendments to the fiscal framework or revenue proposals, amendments to the revenue proposals must comply with section 11.3 of this Act. The minister must be given at least 2 days to respond to the report and any proposed amendments prior to the submission of the respective reports to the House. And C, the respective reports of the Committee on Finance must include the responses of the minister. So you now have a 3-stage. Minister responds, goes back to the committee, and then it goes back to Parliament.
Okay. I just want to ask this last question from my side. You said that you agree with Ms. Pillay that it's not the court that has to engage with the test of whether or not that increase should have been done or not, should have been effected or not. But what you're asking is that the court should look at the duty that Parliament had to engage with this issue. Is that the case that's been pleaded by the EFF?
Yes, in fact we argued it, not just pleaded it.
Okay.
But it's certainly the case, both pleaded and certainly in the founding and in the reply, we complained a lot about sort of Parliament's poo-pooing of the equality programs that is created. But in the reply we attached a full paper by a learned person from the EFF who's an economist. And we argued it fully in the papers, but it's split.
All right, we're just going to ask for a few minutes. We're just going to adjourn for just 2 minutes, and we'll come back just now. Court adjourns.